Yes, you can talk to your employer. You still have an employer-employee relationship, and your attorney does not get involved in that when we're representing you in your workers' compensation claim. However, you have to also realize that sometimes the employer asks questions or tries to get information that they're not entitled to. And so if they ask you anything about your case or about resigning, or if they ask you to sign anything, or if they're offering you some form of work, you should really discuss that with your lawyer before you sign anything or make any commitments. But you can still talk to them about your job assignments and your hours and that kind of thing. Every case is different. There is no set time frame. A case can be open for one day and it can be open for 20 years. It really is very case dependent. Luckily in Arizona, there's no time limit on a case. So you really just have to speak with your lawyer about your particular case and the facts and try to gauge that on an individual case-by-case basis. If you've been terminated from your employment, or if your employer's just not offering you any hours to work, you actually have an obligation to look for work, alternative work within your work restrictions that have been provided by your physician. So you do want to do that, but if you have any questions about it, you should speak to your lawyer because every situation is a little bit different. No, you should not discuss your case with your employer. The only one you should discuss your case with is your attorney. So if your employer asks you any questions about your case, the only thing that you would want to disclose to them is your work restrictions from your physician. So if your doctor has provided you with a list of duties that you should or should not do, I even tell people put a copy of it in their pocket and take it with them. But you do want to provide that to your employer so they know if they can accommodate you or not. Other than that, you really shouldn't talk to them about your claim unless your attorney advises you to do so. Yes, you can file for unemployment. You can receive workers' compensation benefits and unemployment at the same time. You can also get Social Security disability benefits. So the fact that you are receiving or that you may receive workers' compensation benefits should not preclude you or prevent you from applying for or receiving other forms of assistance or income. We would need to know if you're receiving unemployment or Social Security because sometimes there can be offsets or some interplay that can be dealt with, again, on a case-by-case basis. When you are represented by an attorney, all of your communications, which includes checks, needs to go through the lawyer. So if you receive a check directly from the insurance company, you need to tell your attorney that you received it. You need to tell them before you take it to the bank or you cash it. We need to have that check so we can record it, put it into the trust account, and make sure we have a record of not only that the check was received, but the amount of the check and the dates the check covers.